morning.
Good morning, Your Honor. May it please the Court, my name is Paul Rabine. I represent Sean Gray, the plaintiff in this underlying automobile accident case. Mr. Gray is here in the courtroom, and also here is Melody Manning from my office. This is a case where the trial court dismissed our case based upon fraud on the court, saying that my client had testified in his deposition untruthfully. As the court is aware, this is an extreme remedy. There are two reasons why this court should reverse the lower court's decision. The first one is very easy.
Mr. Rabin, excuse me, do you want some rebuttal time?
Yeah, 5 minutes.
5 minutes, fine.
Thank you. I appreciate that. First one, easy. We asked for an evidentiary hearing. We had witnesses present at the hearing. The judge refused to hear them. There is no case in this DCA that we've been able to find where someone asked for an evidentiary hearing on a motion to dismiss based on fraud, where the judge denied that request, refused to hear from the plaintiff, and dismissed the case.
Clarify for me, did the trial court receive documentary evidence, and what's missing is therefore the testimonial aspect?
It depends on what you mean by evidence. Was anything admitted into evidence? Were they sworn? No. It was just medical records. Were they sworn to? No. Were they authenticated? No. Did we object to them? Yes. But there was a deposition also attached to the motion to dismiss, which was sworn testimony. So there was some evidence, there were some records, but they're not authenticated. I raised that at the hearing. He wanted to explain some of the things that are going on in the records and just was not allowed to.
And your core contention is that your client was precluded from offering sworn testimony at the hearing.
My client and the other witnesses that we brought to the hearing, his mother and his brother. And if you read the transcript, and I encourage you to do that, at the beginning, the judge is like, oh, I wasn't expecting any witnesses. Maybe we should not do this today. And we said, we want to put on the witnesses. And he said, well, let me hear the arguments first, and then I'll decide if I want to have witnesses. Then we get into the arguments, and at the end, he doesn't allow my client to testify. And so the case law.
Is there anything, you said you found no case. I mean, does he have an affirmative obligation to hold a hearing, or is it within the trial court's discretion?
The case law, as it now stands, and we've cited it in our brief, doesn't require an evidentiary hearing. But we could find no case where there wasn't an evidentiary hearing, or one was requested and the request was denied, that the court upheld the dismissal. And I would propose that an advancement in the case law that this court could make today is to simply require an evidentiary hearing. The cases all discuss it. All the cases we found where there wasn't an evidentiary hearing appear to be reversed. So that may be an advancement, but no, the case law as it now stands does not require it, but it's a better practice to have one. And certainly, if somebody asks for one, I think it's an abuse of discretion to deny that request, especially when the witnesses are present at the hearing and ready to testify. So that's point number one.
Was there a proffer to the judge as to what the testimony of the witnesses present would have said?
I did make a proffer at the end of the case, but I have to go back to the specific language. My proffer was, I would like my clients to explain these medical records and review them and go through point by point exactly what they said. So I did make a proffer. He didn't want to hear it.
Does the trial court at some point indicate, well, I will assume he's going to explain it, or some language to that effect? Basically anticipating what your client would testify to?
No. I mean, there's language that the trial court used where he said certain things were undisputable. and he would assume that my client was going to deny them, but they're undisputable. And
Well,
so
one-
this is an interesting,
One thing that appeared to me as I read the transcript that the court deemed indisputable was Dr. Zhu, X-U-E, the acupuncturist. And here's what I wanted to point out. There was a factual dispute as to whether those records of Dr. Zhu were your client's or your client's brother's records. That in and of itself might lend itself for a hearing, but it appears that it was not disputed that your client relied on Dr. Zhu's records when he appealed the denial of unemployment benefits. Is there any dispute as to that?
there is, and
Okay.
here's what it is. The defense made it sound like my client attached all the records that said that there was TMJ treatment to the unemployment denial. He didn't. They're just 3 little notes that don't talk about TMJ. They don't mention the word TMJ anywhere. They do mention headaches. I'll give you that. The other thing is the documents that the court had, as far as I can tell, are unreadable. Those medical records, I can't read what they say. The defense quotes what they say, but I can't read it, and I don't think the judge could read it either.
And as to the acupuncturist, though, didn't the judge sort of discount, in fact, perhaps even ignored those records and relied pretty much exclusively on the dental records? So
Yes.
if there were a factual dispute as to the acupuncturist, the trial court sort of put that to the side.
Correct.
Okay.
And this is a crucial point here. The judge acknowledged at the hearing and in the order that there was a factual issue. He doesn't come out and say, I'm not considering them, or if it was only these records, I wouldn't do this, because there's a factual issue. One of the things that makes this case unique is this is not a case where my client is confronted with medical records and later goes, oh yeah, that's true, I did get that treatment. He has consistently testified that these are not accurate records. He did not get TMJ treatment from Dr. Zhu. And one of the things that's really, I want to make sure you catch is, the accident where Dr. Zhu treated him was in 2009. My client goes to a PIP IME in 2010, and the IME doctor is talking about TMJ. My client's like, I never had TMJ treatment by Dr. Zhu. He writes a letter to Dr. Zhu and to the IME company saying, I never got TMJ treatment. Okay, this is all before this accident in this case. Why would anybody do that? He didn't know he was going to have this accident in this case. That calls into question these records. And that's been his position all along. But this is one thing that makes this case unique. He's saying, yeah, this is what the doctor said are my records, but that's not what happened. Now, one of the things...
But if the judge, let's assume the judge said, okay, there's a factual dispute as to whether those records are your client's or your client's brother. And the judge concludes, well, I'm not going to rely on them.
Correct. And
So you certainly could not argue that you're entitled to an evidentiary hearing if the judge said, I'm not going to rely on them for purposes of the motion to dismiss.
correct
Okay.
on those, but we were entitled to an evidentiary hearing on the dental records. And let me just point out a couple of really critical facts, because I don't think the judge was relying on Dr. Zhu's records. It's like factual dispute. But the judge got some facts wrong. Just got the facts wrong on the dental records. And I take responsibility for that because I wasn't prepared enough to rebut what defense counsel said. But if you look at those records, and I encourage you to read those dental records, there were statements that the court relied on about the content of those records that were false. Many statements. First one, defense counsel said the records showed that my client had yearly TMJ complaints. That's at the record on page 239. We go to get his dental records from Dr. Ferrulo, And dating back to '01, yearly TMJ complaints going all the way back, all the way to March of 2010, about 6 months before our accident. If you look at the judge's order, this is page 184 of the records, he says it's hard to believe the plaintiff would have forgotten a 12-year history of TMJ pain and headaches, particularly when extensive treatment occurred just months before the accident. It's not true. 2 references in the dental records. 2. One in 2001, when he's 15 years old. There's a little form, and this is at the record on page 263. There's a little form, and it says, are you suffering from jaw, let me look at it, clicking, I think it said, and it's checked yes. First of all, we don't even know if it was my client, who was a 15-year-old at the time, that checked that off for his mother. That's record number 1. Number 2 is a note dated 3/4/10, where my client is coming in after having tonsillitis, and the note says, and we don't know who wrote the note, we don't even know if it was Dr. Ferrullo or a nurse or who it was. It said, right side TMJ is clicking, started after having tonsillitis back in January. Okay? The jaw popping one, the one that from the intake sheet 3801 is on page 99. It says, someone checked clicking, popping jaw.
Well, your brief indicates there were 5 dates of TMJ complaints. March '01, March '05, August '06, September '06, and March of 2010.
That is not what the dental records say. There were some other records that are not in this record from his primary care that when he suffered, he had impacted wisdom teeth in '06, and it does reference jaw pain. Okay? Those aren't in the records. I'm just talking about what's in the dental records. Those records were not even before the court.
Okay, so with an evidentiary hearing, your client could have explained that on that particular date, that was related to wisdom teeth extraction pain or something like that. That's temporary.
It was
not traumatic.
Yes. Yes. So here we have a representation, yearly TMJ complaints showing in these dental records, and the judge is turning to me and going, is what he's saying true? And the only thing I could say is, I don't know if it's true or not. I would like to look through them. I would like to have my client go through them. He did not want to hear it. And I take responsibility that there were only a couple of them mentioned in the brief. And so we have a bunch of handwritten notes. I did not want to say something that wasn't true, but I wanted my client to be able to speak. And he wanted to speak, and he just wasn't allowed to. But we don't have yearly complaints. We don't have a 12-year history of TMJ. Now, the pain from the jaw, when you have your wisdom teeth pulled, that's not TMJ complaints. I'm in pain because my wisdom teeth are impacted and I'm getting pulled out. I want some Vicodin. So that's first false statement. Second false statement. Defense counsel said that there were about 10 complaints, annual exams, where he had TMJ complaints. It's on the record at page 242. And this is defense counsel. So you don't remember if you ever told Dr. Ferrullo you had pain in your jaw. No, he's referring to the deposition testimony. Well, we went and got the records. There's about at least 10 points, annual exams, he had TMJ complaints. This is not true. Look at the dental records yourself. It's not in there. The dental records only show the intake in '01, 15 years old, clicking, checked. Is that a complaint? I don't know. And then the complaint when he had his, the complaint of jaw pain when he had his wisdom teeth removed in '06, and then the thing in 2010 when he had the tonsillitis and it said TMJ is clicking. We don't know if he even said the word TMJ or whether that was a dental person writing that down? We don't know. Another good point, though, unlike other cases, these records were not presented at the deposition, the dental records. Hey, your dental records say this. What do you have to say about that? He was never shown his dental records.
You're at 15 minutes, Mr. Reagan.
Okay.
So use
We're at 15?
Yeah, you're at 15.
All right.
So use your 5 as you wish.
I will. The next false statement is about the severe jaw pain requiring Vicodin. The representation was that my client made complaints about extreme TMJ complaints where he needed Vicodin prescribed. This isn't just a little minor jaw pain. This is Vicodin where it's extreme pain 6 months before the accident. That's at the record at 253. This is not true. The Vicodin was prescribed in 2006 when he had the wisdom teeth removed. That's 4 years before the accident. It wasn't for TMJ pain. My client was never, Dr. Ferrillo never diagnosed him with TMJ disorder. The letters TMJ only appear in Ferrillo's records once. I take responsibility for what happened. Judge turned to me, hey, is what he's saying true? I wasn't prepared to tell him, hey, I've counted these up. This is not true. Don't base your ruling on this. But what I did say is, let's look at him. Let's have my client get on the stand and testify about him. But he didn't want to hear it, and he denied the evidentiary hearing. We ask that you reverse completely because these small amount, there's a fact issue as to Dr. Zhu. These small amount of records are not enough to warrant dismissal of this case. And the alternative, we ask that you reverse and send us back for an evidentiary hearing.
Thanks, Mr. Redmond. I'll give you 3 minutes on rebuttal.
Good morning, Your Honors.
Good morning.
May it please the Court?
Hold on just a second. I'm playing timekeeper. Go ahead. I'm sorry.
Joe Kopaz on behalf of the appellees from the law firm Lux Santinello. I want to first state that trial court's ruling should be affirmed because there was clear evidence in the record of Mr. Gray's false testimony under oath.
Let me ask you a question. If the law prefers an adjudication on the merits, what is the harm in having the plaintiff testify and be confronted with these records in front of the judge? What's the harm?
Your Honor.
Why did you object?
I don't know if I objected, but we had a deposition, a 4-hour deposition.
Well, when there was an ore tennis motion for a hearing, you objected. Court sustained it and refused to have a hearing.
I think
So
there was an...
Why don't you just confront the plaintiff with these records? Because a lot of these questions in the deposition are, do you remember? I'm not sure how you prove fraud when a plaintiff testifies he doesn't remember. You can't even impeach anybody when they say they don't remember. How can you prove fraud when someone says they don't remember?
Didn't remember on the dental records that showed 10 years of TMJ. There was questions, did you ever have any jaw complaints at all? He said he'd never had any jaw complaints of any kind. So I'm sitting there facing, he went to Dr. Bolin after this accident, got a surgical referral for DMJ search. So first instance, did he have any prior complaints? So there were just general questions. Did you have any pain in your jaw before? No. And then going back to Dr. Zhu's records are the ones that really stuck out at me at first when we were addressing whether this was a fraud case or not. He treated with Dr. Zhu in 2009 for 21 treatments showing both headaches and TMJ. 21 treatments from July 27, 2009 to December 13, 2009. Those records are wrong. They were my brother's records. His brother treated with Dr. Zhu in 2006. The key point here, Mr. Gray went to Dr. Zhu again following this accident for 20 more treatments that refer to the 2009 treatments.
But did the judge rely on Dr. Zhu's records?
That was one, if it was just Dr. Zhu, but then we get a little bit further. At the time of the accident, 2009, he was working for POTS, an employment, his employer.
Well, I know what's coming next because he relied on Dr. Zhu's records to appeal the denial of the unemployment benefits. But my question is, did Judge Shames rely on Dr. Zhu's records?
It started with Dr. Zhu's records. Are these accurate? Then we go to Dr. Ferrillo's records, and they both make sense with that. There are prior complaints when Mr. Gray's getting asked direct questions. Have you ever had any headaches before that's caused you to miss work? No. Here's positive where you sought unemployment benefits for like 10 to 12 days of missed work because of headaches. There's two issues. There's a TMJ issue, and then there's a headache issue. Both he's claiming he never had before. I don't know if this was a potential brain injury case from this auto accident or a brain injury plus a TMJ. It wasn't clear, but there was countless misrepresentation. Clear, no, not that I don't remember. I've never had any headaches cause me to miss work. Then those records were presented to Mr. Gray during his deposition, and he says, oh yeah, I must have forgot about it. So if I would have presented a dental record, I must have forgot. It's like, we come to court, we seek the truth. I mean, I was just asking general questions. Did you have any prior jaw pain? If you said, maybe back when I was 15, I had some popping, clicking. I wasn't asking about TMJ symptoms, just jaw pain in general, right side, left side. No, I've never had any jaw pain whatsoever before this accident. And I counted like 38, Dr. Zhu treated him 21 times where he's sticking his finger in his mouth because he has jaw pain. This isn't
Well, we do know at least from the records that 2 incidents of jaw pain could be related to tonsillitis and wisdom teeth, which could have been explained away.
He could explain when I asked him at deposition, have you ever had any jaw pain? Yeah, I had jaw pain with tonsillitis, which was March of 2000, where he did get prescribed Vicodin. It was extreme pain. This is 6 months before this accident. And to address Judge Crenshaw's question, whether there was any evidence in the record, my motion to dismiss for fraud was pending for 6 months because the original counsel dropped out after I filed the motion. After the deposition, after the prior attorney sat through and realized at that point his client wasn't exactly accurate during the deposition, he withdrew. He got a new counsel. And Judge Crenshaw asked was there any evidence. Did they have a time to submit evidence to the court? They didn't file a response to the motion to dismiss. They could have filed records from whoever to indicate he never had any TMJ complaints. I mean, this motion was pending for a...
Tell me this. Is there any case that requires them to file an affidavit in opposition to your motion?
No, Your Honor.
But the burden is still upon you to come forward with some evidence. And unlike summary judgment, their failure to come forward with a written response doesn't deprive them of their right to an evidentiary hearing, does it?
But they could submit evidence at this hearing. The term
Is that not what they asked when they asked to present testimony? To present evidence.
This was during the first hearing. They could have submitted evidence before this hearing started. The term evidentiary hearing, the judge would have allowed written medical records. Judge didn't want Mr. Gray to explain all the discrepancies in his deposition that were clearly, these weren't ambiguous questions. Have you ever had any headaches before this October 2010 accident? No. Have you had any jaw pain? No. I mean, it couldn't get any clearer of the questions. Should I present him with dental records after he already admitted the unemployment records were false? I probably could have went one step further with that. But how many times do you have to lie under oath before it gets to the point where it's just not tolerated? Here, many cases, generally the cases we see that potential, we don't always remember what's in our medical records. 30 years before you had maybe a back, it's usually back, because some people think they have neck pain, back pain. This is a jaw pain in your face. I mean, you know if you've had jaw pain previously. So I don't know, the judge recognized, what would Mr. Gray testify to? Now I remember having jaw pain. This is the same case, the Ramey case, the Ramey case.
But why not let him testify, and then the judge can assess credibility and after a full evidentiary hearing decide on what to do? It's like I got you. I'm going to get an answer to a question, and maybe I don't remember. Maybe I legitimately don't remember. And then you come into court, and you've got the medical record, and say, ha, I got you.
Well, he was given that. We had a 4-hour deposition where question after question was asked. Why couldn't he be truthful during the deposition? Why does it take being in front of the judge? Then back to it's not. If this was a perjury trial, he wouldn't get the chance. I'm sorry, I just didn't remember. This is the same scenario.
He would have a chance to testify, though.
He had a chance to testify during his deposition.
But
if it were a perjury trial, he would have the opportunity to testify.
And if
this was a motion to dismiss hearing where he specifically requested an opportunity to testify and was denied. And the end result is that he's thrown out of court.
Right, that's why when you're sworn under oath to tell the truth, nothing but the truth, you should tell, if he's at a perjury trial and he can't recant the perjurous testimony, then, I mean, if you go through the deposition, and I request that you go through the exact question, because there's no ambiguity in some of the questions. It's straight, point-blank questions. Have you ever had, it started with the headaches.
Well, if your deposition testimony is so strong and in your favor, then it shouldn't change after an evidentiary hearing, according to you. What we're concerned about is, at no point in time was the plaintiff confronted with these records, particularly records. I mean, you're 15 years old. You got wisdom teeth pain. You got tonsillitis, and you're saying my jaw hurts. Is that something you're going to tell a jury? Well, he had jaw pain, lied about it. It's probably not going to fly with a jury these days. What I'm saying is, what concerns us is he was never, ever confronted with these. You asked him some questions general questions about prior headaches, TMJ pain, things like that. You have those questions. That's written in stone. And then you would have an opportunity to cross-examine him at an evidentiary hearing with his deposition or with the use of the other records. So I don't understand what the harm is.
If an evidentiary hearing would have been requested before that hearing, I think it would have been fine. We could have set up an evidentiary hearing. He had a chance to present all the evidence he had. The judge reviewed everything. I think in the mindset, the judge writes a detailed order with the concerns you're addressing now of an evidentiary hearing to have Mr. Gray explain deposition testimony that's not ambiguous. It just gives him it's the same in the Ramey case.
But that's a factual determination. Is there an ambiguity? Are the records inconsistent?
Which records are inconsistent?
His records that you're relying upon to throw him out of court.
Dr. Zhu's records are not inconsistent. There's about 21.
Inconsistent with the other documentary evidence.
No, it's not inconsistent. The documentary evidence we have is inconsistent. We have his dentist that was a long-time dentist, at least 6 treatment complaints of jaw, TMJ clicking. It was one tonsillitis. That's a little different, but it's still jaw pain. His general question, presenting him with a documentary, he says he has no jaw complaint. That's...
Yeah, but it would have been a little bit different because Mr. Arabian's arguing today about the inaccuracy of some of these records. And during an evidentiary hearing, had he been confronted with these records, he could have answered, that wasn't me, that's wrong, that's false. And then the trial judge could decide whether that's credible or not.
The trial judge, under his abuse of discretion standard, he felt like whatever he would have said wouldn't contradict all the documentary evidence that we had and his deposition testimony under oath. It just couldn't be explained away. I mean, in Ramey, there was an evidentiary hearing, and they presented with the records. Oh, that jogged my memory. In Ramey, that wasn't good enough. That doesn't explain giving deposition testimony that's incorrect. And you don't, I mean, I don't think to impeach in front of a jury, you get the document after he's answered it incorrectly. But I don't think on the defense side, it's my obligation to confront him with something he's clearly said he's never had before.
But you're seeking to dismiss this case and bar his opportunity to go to court completely.
Right, Your Honor.
Right. Don't you think that he's allowed an opportunity to respond?
It was a 4 out of, if you read through his deposition, he has plenty of opportunity to respond. And his response is, I've never had any of this before.
I understand. But he's there, he's available, the records are there, he's available to be confronted by the records, and it doesn't happen.
Well, he's confronted with...
And his case is gone.
Well, he's confronted with his employment records that were false. That's at least, he was confronted with a portion that he authenticates was his records that he submitted. And the judge didn't rely on that. Then we have multiple chances. I mean, how many records do I need to present contradicting deposition testimony that's clear? I mean, at some point, I don't like to follow these motions, and usually it's not clear. Here we have, usually it's 1 time, 2 times, I don't remember a certain treatment. Here we have like almost 40 to 50 different, whether it's the headaches. If we just go on the headaches, we have about 30 to 40. Then we go on TMJ.
Well, I'm concerned you may overstate the case, and apparently I'm led to understand that, the representations to the court was, a 12-year history of TMJ problems, but yet I hear that, well, there are only really 5 notations, and if I take out the wisdom teeth and this tonsillectomy, well, then I'm down to 3. I mean, isn't that the kind of thing that calls out for some fleshing out in an evidentiary hearing?
The representation, it was a yearly from dating back to 2001 to 2010, whether it's 5 or 6.
Well, I mean, there's a big thing, but there's a difference between a 12-year history and 5, separate, isolated complaints, isn't there?
There's 5 isolated. That's a good point. There's 5 complaints that you should remember at least one when you're asked a direct question. Have you had any jaw pain? Not TMJ complaints, not clicking, and no jaw complaints whatsoever. Whether it's 5 or 6, you're going to remember that especially when it's 5 months before this accident that you're claiming you need a TMJ surgery that's within $60,000. That's something you should remember. And so it's real detailed when he's submitting. Even the PIP Geico addressed the letter about the TMJ. He also said he never had any headaches. And within that letter, he says he's never had any headaches in that letter. Now we know that wasn't accurate either. So at what point, how many more times do we have to go down the rabbit trails, like when the testimony is not true? I mean, I don't know what evidence you're hearing. He could have presented all the Dr. Ferrulli, he could have presented other dental records at the evidence hearing. The judge wasn't not allowing. He just didn't want to hear Mr. Gray explain why his deposition wasn't accurate. I mean, and I think that's within
that's the heart of what an evidentiary hearing would have found out.
It was within his discretion. He thought he knew exactly. He didn't say, "Oh, now I jogged my memory. I did have jaw pain these 5 or 6 times. Oh yeah, I did have these headaches 27 times before." I mean, I think it was within his discretion to say, "I'm not going to let this go on any further." And he even knew this was the first time he's ever 99.9% of the time he let this case go to the jury. This one case, it is more the demeanor at the hearing too. Mr. Gray was there. It was just.
I don't need to know that because there's nothing that tells me what his demeanor was.
Okay.
So don't go there.
Thank you. Any more questions, Your Honor?
I'm not cutting you off. I
No,
just don't want
no,
to hear
I
stuff that's
understand.
not in the record.
Yeah, absolutely. Any more questions? I just request the trial court's decision be affirmed, and then to clarify a little bit, I don't know if the request was just to let the case go forward. I don't know if it did get remanded, whether now is an evidentiary hearing wasn't clear based on their response. I request either if it gets sent back, at least for evidentiary hearing, or get affirmed.
Okay.
Thanks.
Thank you, sir. Mr. Rabin, how about 3 minutes?
Okay. The defense did not object to the evidentiary hearing. I think that's an important fact, too. The judge did this on his own. There was no objection. They just said, "Oh, we don't want this to happen." The judge said, "Not doing it." At the beginning, he's saying, "I'm probably going to do this, but let's hear what you have to say." Then he says, "I'm not doing it." So there's no objection.
You do agree it's an abuse of discretion standard?
Of course. Of course. And then there's the language about when if it's not an evidentiary hearing, then, and it's clear and convincing.
Would you admit also, I mean, the questions that were asked at the deposition were pretty clear and really call for a yes, no answer?
I wouldn't agree with that with all of them because, like, the headaches thing, he testified, "Did you ever have headaches?" He said, "Well, I never had, like, migraines or anything like that." It wasn't like a yes, no answer there. But the other thing I want to just point out about Dr. Zhu's records, what we were thinking may have happened is that, you know how sometimes a doctor clones previous records to start off a report? I don't know if that's ever happened, but that's kind of what it started to look like to us. And we don't know why Dr. Zhu did what he did, and if we have an evidentiary hearing, I'm going to call him and ask him. But kind of our theory is that maybe these were some cloned records used to start as a basis for the treatment. We don't know what happened. But what's significant is from the get-go, from before this accident even happened, my client was saying, "These are not right." He said it in his interrogatories. He He said, I know about these records, but they're not right. And that's what's really interesting about this case. One last point, a way to frame it. What do you do if you don't agree with what a doctor wrote in your medical records? Does the doctor's version stand unsworn? Or do you get a chance to say something about it? This case, my client doesn't agree with what was written in those records and hasn't agreed from before this accident even happened. But if the court were to uphold what the trial court did, it would basically say, you know, we're going to take the doctor's word over your word. And in this state, we have a constitutional right to a jury trial. We have a right to be heard. My client was denied that right. I ask that you restore that to him. Thank you.
Thank you, Mr. Reed. Our next case, we're going to take a 10-minute break, and then we will come back for Roker versus Tower Hill.